I'm very pleased to have the opportunity today to welcome Marta Bucholc. It is an extraordinary pleasure to discuss her way to think the law and society, even in terms of in cultural and civilizational terms that might lead to a new concept, as I lastly call it, a new sociology, cultural sociology of the law. This might be possible to go in this direction together with your insights. We have one problem only: to make acquaintance with her writings. That is, on the one hand, it is a lot, and also in Polish, that some of us do not master sufficiently, and we apologize for that. On the other side, in order to follow up the translation you have done of the Temps des Tribus of Michel Maffesoli, might also give a lot of insights in the way that you translate tribes, communities, communal life, and the mastering of the world by tribal structures, as Maffesoli called it, and the role that the shadow of the Dionysus might play in this game. A very interesting discussion. On the other hand, we have certainly, and I won't reduce you to that, but there are great Polish traditions that were for a while better known in Germany too, and in the world, Znaniecki, and I was so impressed when I saw that you got this Znaniecki Prize Award from the Polish Sociological Association, what is, for everybody who ever read this wonderful book about the peasant in Europe, as a really a great reward. It continues, and you have seen that in discussions with her, and you know this, that is the position you had at the Institute for Human Sciences in Vienna, and so forth. It is really impressive, but there is something lacking, excuse me to say, I must say it. That is, that we do not have sufficient writings in German. And this is, of course, not a reproach to you, but a reproach to those who didn't translate you until now. And this will come. I'm very sure about that, because whenever we had discussions in smaller groups or in our fellow meetings or during other occasions, we were always very much impressed by your really very deep insights. The list of publications is really long, is an interesting one, where some topics are centered around really an understanding of the law on the one hand, and on the other side to find out some general traits and characteristics of modern societies in a very general sense. This corresponds to a double way to the humanities, from the law on the one side and from sociology from the other side. And bringing both together may lead also to a figure like Norbert Elias. Norbert Elias, and this is something very, very special and very crazy also, who is so much adored for his analysis of manners. His manner books was a methodological idea of absolutely first grade, and also from the theoretical insight to bring the analysis of the psychological apparatus on the one hand, and structures of society, differentiation and centralization of power together, in order to see how the inner world of the individual is formed in order to be and to become what he calls a civilized man. And this analysis of civilization as a process has become then the great project of Elias, and you will tell us in your talk today about the importance and the reach that a new analysis and a fresh analysis of Elias might have in order to get a better understanding of law and religion two realms of normativity in Elias' writing that were not worked out as a source of normativity as such, but if it is true that Elias is so important for an understanding of the modern world, how is it possible that he can do that without looking at religion and without looking at law, or what kind of misunderstanding is behind? Or is he perhaps doing nothing than to work about the law? That's my suspicion, but disguised in other concepts, notions, and so forth. You will explain us, and thank you so much for coming. That she is fellow since October. Everybody knows it by personal interaction and learning situations. When you have to read that, it's a little bit like Bakshi and sending emails or saying there you could improve your really bad knowledge. So go ahead. Very welcome in this circle and this evening. Thank you so much.
Thank you very much, Professor Gebhardt, for introducing me so as I would feel, well, a bit better than a few minutes ago. And, well, the title of this talk is really a rather long one. It's actually the title of my research project here. It's not the best title for a talk. I'm fully aware of it. So maybe I should tell you in the first place what I wish to do in this lecture. So I wish to achieve two goals, maybe. Firstly, I intend to place the reflection on law and globalization on these two topics in Norbert Elias's theoretical framework, which is not easy for the reasons I will discuss with you in a minute. And secondly, I wish to apply the notions of involvement and detachment, which were worked out by Elias, to legal concepts and standards in order to test whether these notions could be used in comparative research on legal cultures. And of course, in science, we always need to tell not only what we are going to do, but why we are going to try and make our audiences interested in what we are going to do. So why do I think this is interesting? Firstly, because it may help us clarify a mystery in Elias's account of social change. And Professor Gebhardt has already indicated this mystery. Where does the mystery lie? From his writings, two factors are absent which used to feature extensively in all theories of modernization and social change: law and religion. There is nothing about religion virtually, and almost nothing about the law. And the almost nothing you will see in two slides actually today. So there are two slides on law in Elias. And I will try to fill in this gap. Of course, reasons were given for the absence of religion, and Job Holtzblum tried to give many good reasons why there is no religion in Elias. I don't think these are good reasons. I think he just didn't like religion for some reason or other. Anyway, I will try to fill in this gap as far as law is concerned, and I will try to show that there is in fact a place for law in Elias's theory, even though it may require us to rethink our ideas of law. Secondly, what I'm going to say is, I guess, interesting to me at least, because it may help to overcome a myth that Elias is a Eurocentric and old-fashioned theorist and he can only be referred to by cultural scientists. This is a stereotype, well, very, very much alive in Poland now. And as you might be aware of, a stereotype of cultural science is that these are sciences that are dealing in a sloppy manner with culture by means of free associations. So Elias is often perceived as someone who does exactly that. I don't think it does him justice. And I can tell you an anecdote about a student of mine who was supposed to read a part on the process of civilization, and afterwards he came to the class and he said, "Oh, how can you write like this after Foucault?" So I think you could write like this even after Foucault, and as you will see, the fact that my student could have read Elias as though it was contemporary writing, bad in his opinion, but contemporary, is the best argument to show that he really can be still read as someone vitally important for our thinking about our time. And thirdly, I would like to try and look for answers to a few problems which overshadow the efforts of this college, basically, the efforts of comparative research in sociology of law, in legal cultures. And what are these problems? It is not my field of specialty. This is something I'm drawing from the discussions that we are leading here ever since I've come here, and the books I'm reading as a result of these discussions. And it seems to me that there are three main problems. First, what is special about the law? Where does the law end? What is actually the law that we are talking about? Secondly, what is cultural about the law? This is a question that Jamal Malik once posed in a very inquisitive manner, and it really inspired me to ask what is cultural about the law in Elias's thinking, if we can find the law there, which is also questionable. And if we try to adopt the thesis that there is a connection between law and culture, they are intrinsically linked, as we do in this college, then how can we compare legal cultures in any manner whatsoever? How can we compare incomparables? There is a strong sense in our thinking about culture that cultures are not comparable because they are not explainable in any extra-cultural terms. You may compare the effects of a culture. You may set up a measure for classification of cultures. This is being done, actually. But there would always be a limit to it. There would be a certain dimension which I would call the unexplained rest. And the unexplained rest makes us think that any comparison would indeed be a far-fetched thing. And besides, there is of course a problem into which I'm not going to go in this talk, of cultural roots of any categories which might be applied in this sort of comparative research. And hence the fear of ethnocentrism, which may easily turn, we are talking about ethnocentrism, which is ethnocentric itself, I guess, because it might, in the Eurocentric version of it, which may easily turn into a different kind of centrism altogether, if there comes another perspective which will take place of what we are having now. So, I guess that every researcher of law as culture should answer these three questions, and I will show you what answers to them can be found in Elias, the way I read him. So, what is so special about the law? The first answer is nothing. Nothing whatsoever. So, the law is, as you see, something that corresponds at all times to the structure of society. Seems reasonable enough. Legal norms set down in writing presuppose a very high degree of social integration and formation of central institutions able to give one and the same law universal validity throughout the area they control. The power that backs up legal titles and property claims is no longer directly visible. In proportion to individuals, it is so great and so self-evident that it is very seldom put to the test. It is a very important piece on the process of civilization. I'm using all the time. I'm using the New Dublin Collected Works edition of Elias. This is not the only one, and this is a chaos that you could hardly imagine that we have now with the various editions of Elias. So this is the recent one, I should say. What is striking in this quotation, apart from the associations to hopes that you might make and to other authors who are really interested in the central power as a source of normativity. What is striking is this, sorry, I should use that, I know, is this visibility problem. This visibility problem comes up in a very characteristic connection. Elias is discussing the potential surprise that we might feel when finding out that the medieval feudal lords did not defend their good rights against central power, against people like the French kings like Louis XVI, who were just trying to take the power of them, take it from them and make it their own. Why didn't they raise a legal claim that they had? What Elias is showing is the fact that, this is in the last slide, that in feudal society, power was less concealed, power was more visible. Therefore, the power as a foundation of the law was also more visible. In contemporary societies, power is more concealed, and as a result of it, what we are thinking about the law really refers to a set of norms whose source and foundation we no longer see. Of course, another association that you might have is to Karl Marx, of course, in this connection. And there is, of course, a good reason to say that there is a lot of Marxism in Elias's thinking on the process of civilization. I would be happy to discuss that with you later on. It is not quite material at this point of my talk. What is material is that what follows from these two quotes is that law is a term for bulk of norms which are not essentially or functionally different from other social norms. There are differences resulting of social perception of law, of this concealment, but they are not really bearing on the explanation of law. And another thing that should be mentioned here is that norms, all norms, including legal norms, are, according to Elias, rules for human behavior in groups. So they are rules pertaining to behavior of an individual as a member of a group, towards his own group, or members of other groups. And another problem that you might raise in this point is what is the relationship between a norm and the standard? Because what Elias discusses, in fact, are standards of eating, standards of behavior at the table, standards of behavior when traveling, and so on. So what he says here is that standards of conduct can be seen from two angles. They might be seen from the viewpoint of the individual as rules, norms, or controls. But this is one perspective. Second, standards can be viewed as representing a certain stage of development. In this case, expressions such as stages or levels would relate to the situation, but what is indicated by these expressions is identical with what concepts like norm, standard, regulation, model, and so on relate to. Only the perspective is different. What can he mean by that? This does not sound very clear, does it? It isn't. Well, one thing for me to understand this thing here is that reason which is clearly put in this short sentence in another book, the one that I'm going to refer to extensively now, Involvement and Detachment. To remember that all concepts, including norms and standards, refer to human beings living in groups, to people who can say I as well as we, you as well as they, is one of the basic propositions here and in all other writings by Elias. So this is, of course, an idea that was brought to my mind by our recent discussion during the Fellows meeting on collectivities. And I discovered that what you, Martin, insisted on, that we should recreate the notion of collectivity and a sense, all that's related to this notion in sociology. It really inspired me to look at Elias from this point of view. And from this point of view, this quote becomes a bit clearer, because there is an individual aspect of the problem. And norms are rules for the behavior of an individual, but they are also standards of a certain state of society, standards that are made by people living at a certain time in a certain society. And I guess that it might even be put a bit clearer. That's what I'm trying to do now, and I'm trying to perceive standards as actually sets of norms, so to say. Sets of norms meaning if you get a norm like use a fork at the table, use a knife at the table, use a spoon at the table, don't clean your nose on the tablecloth, and so on, all the rules that Elias is discussing in his analysis of table manners, they form a standard of eating. They form a standard of table behaviors. This is actually a set of norms construed like a checklist. You do that, you do that, you do that, you do that. Okay, you're 100% fine with the standard. If you do everything right, but there is one thing you do wrong, you're almost in accordance with the standard. Therefore, a standard is a more flexible notion, in fact, than a norm. And I guess that's why Elias is really using it. Standard is also more dynamic because norms might be replaced in the checklist and replaced by other norms, such as eat fish with 2 forks. You know, there came a time when this was a norm introduced to the eating standard. But it is not exactly salient to this stage of our thinking. What is salient, however, is that these standards, as analyzed by Elias, they work in different spheres of life. This is something which is, I think, always overlooked when I'm reading commentaries on Elias. This is very seldom made the point of, that he does not refer to actions or even models of actions. He's referring to complexes of actions which are organized according to the division of the life of an individual. It may not be that complex in the medieval times, but you would do well to reflect on the division of spheres of life and standards in various spheres of life that are present in our contemporary societies. And I guess to find this aspect of thinking about social standards, you would do well to refer to Elias's works on sport and leisure. This is where he really touches on the modern condition, I think, and possibly also on the late modern conditions, so to say, with the drastic divisions of standards and the problem of complementarity of standards all over the spheres of life in which an individual lives. And if we look at norms and standards in that way, so if we take into account that in complex societies norms work in various spheres of life and are set into standards which become more and more diversified, then legal norms, taken like this, so like norms set by the central power. Like in our societies, this would typically be statutory norms, but it is not necessary. These legal norms could then be seen as forming a part of different standards and not as an independent standards of their own, and moreover, their interdependence with other kinds of social norms could not no longer be put aside. The legal norms are interwoven with norms which we classify as moral, aesthetical, religious, and so on. And taking up Elias's perspective, we should cease to focus on the provenience of norms, so to say, and reason in a different direction, taking the standards of behavior in various spheres of life as a starting point in comparative practices. This means a larger comparative agenda, I guess, and it would not relate to law only. Any law, meaning the statutory law or any other kind of law, seen separately from other social norms. And it would also have an additional value, I think, of bringing legal research closer to other social scientific endeavors, which would be so very desirable. I have already made that point during our seminar on our conference on the Recht sociology of Weber's, that it would be very desirable that lawyers and sociologists and other social sciences would stop thinking separately about the law. I can give you an example because I tried to do that, although not in a very systematic and theoretically sophisticated manner. In my research, in my PhD project, I was examining the sources, basically mostly newspapers, published by interwar Polish merchants. In the interwar, I mean, in the years between 1918 and 1939, in order to examine the ideal of man that can be seen and interpreted on the basis of this material. And what I found, this was published as a book, unfortunately in Polish as well. Polish people, I guess, should write in Polish as well. Anyway, the book is not available to any of you, which I'm truly very sorry of, because, you could see that what I'm proposing here could actually be put into a research practice. I'm not able to give you a better example. And what I found in this research, which was comparative, I took into account legal norms and also other sorts of norms, including religious ones. And I saw that some legal norms became a part of standards of good conduct in the merchant's activities. Like due diligence when running a joint venture. If a merchant was named to a president of a company, then he was really seeing his own duties in the very same manner that law would see them. There were no inconsistencies that I was aware of. Some other legal norms seemed to have been reinterpreting in a bizarre manner, bizarre for a lawyer at least. For example, a norm that debts are to be paid on time. This norm, in the crisis economy of Poland in this period, was transposed into a different norm, according to which the interest on outstanding debt should be paid in full and with no delay, together with the main sum. But being a debtor and not paying on time was so understandable that this legal norm was in fact not a part of good standard practice. There was not really an opportunity for it to be one. And there were some other legal norms which are absolutely absent, like an obligation to buy Handelszeugnis, it would be in German, so the trade certificate. It was an obligation, but nobody bothered, really. It cost money, and there was no money, really. So, in this case, it was obvious for me that there was no legal standard of merchant's practice that would correspond to anything in their social reality. On the other hand, there were legal norms present in what I interpret as the standard of the merchant's practice. And this would, of course, fall into the spheres of life division very neatly. And there is one more thing that we need to say before we pass to the cultural aspect of the law, that all standards are proper to a certain form of society. And Elias, as we now say, calls this form of society figuration. And I am using this word fully conscious of the fact that Elias did not really use this concept, or he used it in a very non-technical manner, and he really did not intend it to become a technical term that it has become now. We are talking about figurational sociology, and Elias's disciples, let me use this word, are using this term technically. It was not a technical term, but I will use it. It's become a part of scientific practice. So a figuration is a social setting of a certain form and complexity characterized by a distribution of power, ascribing power to certain positions. And individuals and groups in a figuration differ as to their relative power. And none are powerless and none have absolute power, although the distribution may be more or less even. And standards are supported by power, as we have seen in the first quote regarding the law. And standards are generated in the process of social negotiations and struggles for power. These need not be great struggles, these need not be great centralization processes of medieval and early modern Europe. This might as well be small struggles like the one that Elias describes in a wonderful case study of Francis Drake and Thomas Dalton and their conflict during their voyage, which was intended to be a voyage around the world. And it ended up with Drake executing Doughty. Doughty was a gentleman and Drake was a sailorman. And they had a conflict about the right standard of commanding the ship in this voyage. This is a perfect analysis of how struggle for power works in Elias's perspective, which is not a great historical struggle. It's a small struggle on one ship, basically. But it is also struggle for power because there is a relative difference between them, which leads them to confrontation between these two men, as between feudal lords and central kings in what we can read on the civilizing process. And law is just a set of norms, and its relation to power is probably, contrary to what Elias himself thought, to us nowadays, rather more obvious than the relation of law to other kinds of norms, to power of other kinds of norms, such as religious or table manners. Law and power really stick together in our thinking. Maybe that's because of Weber, I don't know. So the second question that we might ask is, if there is nothing special about the law, then maybe there is something cultural about the law. What is cultural about the law? And the answer would be, surprisingly enough, everything, I guess. But in order to understand that, we need to see how culture can be placed in Elias. And now we face the third mystery. Unfortunately, the word culture very seldom appears. And when it even does, it does not have any technical sense whatsoever. It's not the culture that we are thinking of that we meet in Elias's writing. There are a few instances in which the word culture is used, but it is mostly to render the German word Kultur as opposed to civilisation in French, and it's a different discussion whatsoever. It's a discussion of, in fact, two cultural models in our language. So, where could we find culture? Values in Elias are mentioned extremely rarely. And whenever there is a talk of emotions, attitudes, ideals, anything that we typically connect with culture in our practice, it is always in the context of civilization and not culture. Once, Elias in fact addresses this relationship in the following manner. No, this is it. A long line of well-reputed sociologists have suggested that art, in a wider sense culture, in contrast to science, technology and other facets of civilization, are exempt from the sequential order of development that he discusses in the previous passage. Each culture has to be considered as a human manifestation in its own right. Greek art, medieval art, ancient Egyptian religion, these and other products are products of human culture and do not undergo development. More often than not, culture and civilization, the one seen as a process, the other not. You see where the point is. The point is exactly here, in the development word. What he sees as development is, of course, and he insisted on this very strongly, is not the evolution in any sense of becoming better and better. This is not the point in any way. Even fitter and fitter is not exactly the perspective. But it is a change that goes in a certain direction. And this is already a problem when we are thinking about culture. But this is not a problem when we are thinking about civilization, is it? So, we are ready to see civilization as a process and culture not really. They are often placed side by side without a clear account of their connection. The doctrine that he criticizes is probably due to a confusion of fact and value. I'm certain it is. And in terms of their value as human manifestations, as works of art, and an artist is talking, you know, the quality of Elias's artistic production, he was a poet, may be contested. Nevertheless, he certainly was an artist and he felt an artist. This is important. One cannot place Greek and Gothic temples as works of art in sequential order. The same can be said of religious beliefs which they serve to. But if one studies them as social facts, it is not only possible but indispensable to see them as manifestations of different stages in the development of human societies. That's how he explains what he tries to do. And what he tries to do, you see that, well, he's really trying to substitute civilization for culture, in my opinion. And we have moved far from the limited view of culture that's present in this part of this sentence. In contrast to science, technology, and other facets of civilization, we are no longer thinking about culture in these terms. We include science, technology, and all that's related to them into the field of civilizations. We see cultural aspects of our science, for example. Elias would not see that, not of all our science. I guess that culture has dominated civilization in our contemporary discourses, but in order to proceed with this way of thinking about the law as culture, we need to ask ourselves what is the relationship between the two. And I interpret Elias's notion of civilization as a process, of course, and the state of the process, because he uses the terms equivocally sometimes, of gradually imposing restraints on human behavior to an extent which makes it possible for an individual to function in a figuration. This is the psychogenetic aspect of civilization, as he says, and for the figuration to exist by force of coordinated actions of individuals which form these figurations. This would be the sociogenetic aspect. And both these aspects have one in common. They serve the purpose of pacifying social life to an extent sufficient for the figuration to resist the otherwise inevitably destructive power of violence. So this link between civilization and violence in Elias is present in all his writings, and especially as he was aging and he was seeing the world as a place which was really quite as fearful as in his youth. This way at least you could see the picture of the contemporary world that he's given in Involvement and Detachment, and he's writing about the elderly fisherman in a maelstrom. But there is also a very moving picture of contemporary civilization in Humana Conditio, which we have had a chance to discuss during our seminar once. And I believe that he really was perfectly aware of this link between becoming civilized, becoming restrained, and not being violent, and as a result letting other people live and living together with other people. And this is, I guess, the most important assumption that I am making, that violence is really this part of standards that we are applying that relates to our being, pacified enough to be cultural. Because civilization in this meaning is a distinctly anti-cultural concept, isn't it? Figuration and civilization are interwoven, and civilization is explained in structural terms. There is a correspondence between figuration and civilization. There is also a correspondence, or as Elias puts it, complementarity, between standards in various spheres of life, and they depend on them all relying to a certain level of civilization. In order to have certain standards for leisure, for work, for family life, for reproduction, we need to have a certain level of civilization. It is necessary for the network. Elias uses this metaphor, and I think it's really worthwhile to remember that he also already uses it in 1939. And also for the dance, this is another metaphor that he uses, for the social dance to go on. If there is, well, inter arma silent muse, when there is no peace, there is no music, there is nothing to dance to, you can see it that way. And the shape of the figuration is changing, and it may change both direction, and civilization may lead to certain figurational effects, of course. I will not get into that, but ultimately it is the change in figuration which provides explanation to changes in the level of civilization. And this leaves us with a certain problem. Well, two problems. This is a technical problem that we are facing now, but we'll overcome it, and a theoretical problem. This is for you to have a look at something beautiful in the middle of the lecture. Anyway, this is a picture of Watteau, which you might be familiar with, l'embarquement pour l'île de Cité. And this is a very beautiful picture, which is not quite obvious now, but you must take my word for it. And Elias wrote an absolutely wonderful essay on this picture. A very short one, it's called Watteau's Pilgrimage to the Island of Love. And he discusses the fate of both this picture and the myth of Cité, the myth of Island of Love, in various social settings in France, beginning with the times when it was painted, and it was the early 18th century, up until the 19th century. And he explains very insightfully how the motives of this cultural artifact could be interpreted in terms of civilizational restraint imposed on the courtiers of Louis XIV, and he was still alive when Watteau was starting to paint this picture. This really was a very, very long-living king, you know. And plausible as Elias's poetic interpretation may seem, it does not explain why he chose this very motive. Why Island of Love and not something else? Why Baudelaire found it so inspiring a century later, and so on? He cannot explain why it was painting and music, which he also analyzes in his other writings, and not, for example, flower arranging or eroticism, which became the art in which this delicacy of feeling could be shown, which is shown in this picture, and which was, according to Elias, characteristic of the court life, because this was life in which nothing but delicacy of feeling could really be a matter of competition, so to say. This is, of course, a kind of analysis that you might be familiar with, I assume that from a better version, actually, of Alexis de Tocqueville. He says exactly the same thing about the courtiers of French kings, about the Versailles life, and about the reasons for the aristocracy to become courtiers and to become interested so very much in the matters of aesthetics, in art, and all the things that are connected with this sublime state of feelings that for Elias was related to the court society and its version of civilization. Elias cannot explain all that. He cannot explain what determines that these and no other gestures, words and manners were felt to be polite, delicate and subtle. Why was it felt polite? For example, you remember in the process of civilization there is a story about the manner of sleeping with other people in beds when traveling. From the time when it was quite normal to be put with a stranger in one bed when traveling, because innkeepers only had as many beds, up until our times when we cannot actually be put in bed with another person. Even if it be a member of our own family, it would be strange to be suggested that we should sleep with our husband and both children in one bed, in a hotel, for example. And Elias is mentioned that there was a time when rules emerged about behavior in bed with a person with whom one was sleeping. the strange person. And one was not supposed to touch this person. One was supposed to lie aside and not pull on the blanket and so on. He does not explain why it was silly. So why was it felt polite not to touch the person with whom one was sleeping? It is imaginable, I put it to you, that it could have been seen as a polite and proper thing to do, to embrace the person warmly, so that he or she would feel that, okay, I really am happy to share the bed with you, it's okay. You really are thoroughly accepted as my bedmate, so to say. It's imaginable. It's not a nonsense, really. Anyway, as Martin Olbrow put it in his probably first after-war review of the process of civilization, of the German edition of it, Elias does not have an answer to a question which is very, very important for us. What makes civilization civil? We know that it's civil, we know what is it for, to keep violence at bay, but what makes it civil? That's the cultural question. And if we think, it's here, if we think about this culture versus civilization problem, we might do well to consider this quote. The patterns of rationality and affects, the self-images and drive economy of the Germans, the English, the French and the Italians. Polish people do not come into that, unfortunately. Differ in keeping with their different histories of interdependence, this is like path dependency theory, and the social molding of people in the West as a whole differs from that of the Orientals. Elias does write very little about any Orientals, but he makes a comparison between the Chinese and the Japanese in one point, related to the warriors and the part the warriors played in the social structure. And he sometimes referred to the Orient generally, but very rarely, and he did not talk much about things he knew nothing about. That's what I respect about him, really. Anyway, these overall properties of the West, differing from the Orient as such, it might sound a bit, well, not quite up to date, would it? What he really suggests that, well, all these differences are comprehensible because the same human and social regularities underlie them. And these regularities are related to this interdependence of civilization and figuration. And he believes that he can explain these differences. Given enough time, enough sources, enough knowledge about the structure and the processes, he might be able to explain that. So it would seem that Elias is all about civilization, which is basically structure reducible, and culture is nowhere to be found. Well, like almost nowhere, I guess. I think there are 3 works in which the problematic of culture is tackled in Elias, although the term is hardly used. 2 of them are the symbol theory and On Time, deal with symbols. And of course, these are books I am forced to mention which have given him the well-earned name of James Joyce of sociology. These really are incredibly mystic books. And one, Involvement and Detachment, it is not mystical, it's rather well-written book in my opinion, deals principally with knowledge. And it divides both knowledge and symbols into 2 categories. Not into 2 categories, according to 2 criteria. Involvement and detachment. And what is involvement? Let's start with that. Involvement is the knowledge which is like indexed to the person and group in whom and by whom it is shared. It is my knowledge. Involved knowledge is my knowledge. It's a knowledge which has, as Elias puts it, a we function. And as it is a knowledge of a certain person in a certain group, it is typically emotional laden. It is not, as Elias puts it, reality congruent. What he means by reality congruent is not really true in the classical manner. It's rather that it works. It typically works. The more a notion, a symbol is reality congruent, the better it works statistically. So the more numerous are the cases in which our predictions made according to this notion or using this symbol turn out to work in the reality to which they are applied. There is a very good French phrase that renders the nature of this kind of knowledge. This is quant à moi. This is a knowledge quant à moi. And when uttering a phrase using this kind of symbol, an involved symbol, I'm always talking for myself and only for myself. But I'm not always aware of that. And there is another kind of symbol and knowledge which is called detachment. This is a quality of symbols and knowledge. And detachment serves its functions. So it is oriented towards the thing itself. And it is typically neutral emotionally, and it is more often reality congruent. This is not in itself a guarantee for reality congruence, but it is more probable that the detached knowledge will be reality congruent. And I think there is a lot to be said against this classification. Because what Elias proposed for would be to avoid the more philosophically established distinctions like subjectivity and objectivity, or rationality and irrationality. And he wanted to avoid artificial separation of human psychic and social life. And I think he might have gone too far in his wish to avoid philosophy. There is a book on Elias by Richard Kilminster who says that Elias is a post-philosophical sociologist. And I think he was not really as post-philosophical, and he would have had it, but he was doing everything he could to seem so. And in particular, I believe that Elias underestimated the emotional load that may be attached to what he would think would be a reality congruent knowledge. There is no problem for me in imagining that I would be defending what I believe to be reality congruent in Elias's terms, like heliocentric system, because I think it's true and I am emotionally involved in protecting it from people who would say it's not that way around. And this is something for which there is no place really in Elias, so it would be a paradox of a kind that would come to, that you may only be involved in fantasy, really. You may only be really emotionally engaged in things that are not really working well in reality, but that you made up yourself. This is a paradox I will try to come to terms with in the project I'm writing, but I think this is a point that might be raised against this classification. But this classification, if applied to symbols, it allows us, I guess, to determine that the cultural element, which is understood as the rest that cannot be explained in structural terms, the arbitrariness, which is built over the complex of figuration and civilization. So once we become pacified, we may, as I said, become cultural. It is hidden in the involved symbols and what is construed using involved symbols, as this could be also standards of behavior. You might have been wondering where are the standards now, so here they are. One can speak of more involved and more detached forms of knowledge or action, but basically these two concepts relate to different ways in which humans regulate themselves. In their self-regulation, people may be more involved, more detached. Social standards of self-regulation, here he takes this individual aspect of standards, can represent a higher involvement or higher detachment. So can knowledge or art. And he discusses, some of you might remember, involvement and detachment in the introduction. He discusses the influence of involvement and detachment on artistic style. And all statements about involvement and detachment are comparative. This is a very important slide, I guess, for a very important quote for what I'm trying to say, because, well, if law is cultural because it is a part of normative order of society, which is built over a certain level of civilization and incorporates civilizational standards expressed in symbols, then law is cultural insofar involved character can be ascribed to symbols used in formulation of legal norms, and involvement as such being present in it. And the last sentence, that all statements are comparative, can be understood in two ways. Firstly, that you might compare the level of involvement between different stages of the same social setup, the same figuration. But you also can compare these notions between various social setups. You can measure, so to say. It's not a precise measurement, but you can look for involvement and detachment in various standards and various kinds of knowledge. And if these sentences are comparative and make various settings comparable, it could allow us intercultural reasoning, which does not force us to take an ethnocentric viewpoint. It also, it depends on the level of ethnocentricity in these notions, of course. And if they would be viable this way, then they would let us compare the value aspect of cultures and relate cultural aspect of standards of behavior to social structure. So if we take it for granted that we could use these notions, then how, coming to the third question mentioned in the beginning, how could we compare the incomparable? And if we say, okay, it could be done by focusing on the level of involvement, then there are a few aspects which might serve as a tentative operationalization of the level of involvement and detachment in legal research. Firstly, what is the figuration in which people live who follow this norm? What is the civilizational level of this figuration? And it can only mean, if I am right about the violence in Elias, it can only mean how far is this setting pacified? Where are the areas in which violence is still admissible? And how is this violence limited? Secondly, whose power stands behind this norm? What interest does the norm serve? The word interest is decreasing really in appearance in Elias's writing, but on the process of civilization it is still an important word for him. What interest does the norm serve? What kind of interest is it? What symbols are used in the norms? Whose symbols are there? What group uses these symbols? Are these symbols emotion laden? And what social standards incorporate these norms? In what spheres of life are these standards followed, and by whom? And a question that is really rather metaphorical, how big is the we behind these standards? To what extent is the we inclusive or exclusive? This question really seems to me of utmost importance for us. What is, last but not least, the historical dynamic behind the norm? How did it change with the figuration and civilization? And I can let you see one example, which I think might be an interesting case in this field of research, but I'm using something out of the field of my expertise. I'm using an example given by Professor Schmückel once during his lecture, and I think it's also a nice point because it's relating to Rhineland, actually. And the point is that, as you are perfectly aware, and I wasn't aware until I came to Bonn, there was a time when in these parts Code Napoleon was used as a civil law and also in family law and so on, due to, well, unfortunate historical events which took place in this part of Europe. And there was a certain, and one more thing, and the appeal from courts using Code Napoleon was to German courts of second and third instance. This is rather important because there was a funny, or not really funny, provision in Code Napoleon, Article 340, that said, la recherche de la paternité est interdite. You are not really allowed to go and search and look for your father under the law. And of course you may imagine many reasons for Napoleon to have invented, as the legend says, such a provision. Anyway, what is very important is that German courts seem to have interpreted this and all the other provisions of Napoleon's code in a very different manner than the French courts applying the same law. And Dr. Stefan Geyer, I think, he wrote a very interesting book about it, which is called Den Code Civil Richtige Auslegen. I think that's the title. So to interpret the Code Civil in a better way, more correctly. And what was funny about this provision is that French courts, sorry, I might be getting a bit technical. As you see, this is a provision according to which when a woman comes and wants money because she's got a child and the father of this child is not her husband and the child has no father, effectively, she will be told to go away and she gets nothing because this provision forbids it to call the man the father of the child. But French courts had a very ingenious idea to go around this provision. And the idea was as follows. Okay, you cannot say, okay, this man is a father, but you can say he conceived my child. Is it a good word? Okay, it's his child. There was an intercourse of myself and this man is, well, conceiver, zeuger of the child. And based on that, if there was anything illicit about the intercourse, if there was any duress on undue influence or anything like that, French courts would say, okay, you will be allowed compensation, damages for it, based on the general damages grant, which was, I believe, Article 1382 or something. So, based on this article, French court would give this woman her money. Well, and German court would not do that. German court, although given examples from France, would say, no, this provision should be interpreting as aimed at avoiding public scandals. And you cannot have a public scandal of women going for damages for having children. So, no, absolutely not. The case fell. And there were many other examples. Of course, I've chosen the most interesting one for me, which might have been used to show that the involvement of symbol, which is here rendered by the word paternity, paternité, was changing. And in France, it was becoming a technical word, describing the fact of being the father, whereas in Germany, it still functioned in two ways, so to say. So in France, there was a tendency to equal the legal effects of having conceived the child with being a legal father and mother and husband of the mother, whereas in Germany there was a tendency to distinguish these two statuses and these two facts and to put a lot of emotion into the word of paternity, which is protected as a public value. This is a very, very short example of how this notion could be used, and of course to give a full analysis, you would have to know how the societies of France and Germany functioned at the time, what was the historical background, what was the legal culture in terms of institutional practices present in the processes of law in both countries. You could possibly also get into other aspects of civilizational standards in both these countries and cultural unexplained rest built upon them. This is, as I said, just a minor example, but I'm sure anyone could name a lot of fields in which such cases could still be found in our days. And the cases of refugee law, asylum laws, for example, and the cases of family law as well, the cases of cultural differences, which we have also discussed last week in this forum, I think, in the talk about treatment of Australian Aborigines. This is also a case of involvement being transferred and in the legal system. And why do I think this kind of reasoning which would look for involvement and detachment in legal practices, in jurisdictions, in norms of law getting incorporated into standards in various fields of life is important? I guess there are two general factors, the globalization and crisis. And why are they important? Because involvement is not only responsible for the unexplained rest between figurational settings, it has also got a more sinister face, so to say. This we belonging has got two faces. One which makes them engaged, which makes us really committed to what we have, to our own standards. And the other one which makes us afraid of anything new, other, and different from ourselves. And what Elias believes is that fear and risk increase the tendency towards involvement. When I am frightened, I perceive everything as to myself, from my own point of view, and I disregard the more comprehensible we perspective, the bigger we is behind my own we, which is directly interested in a certain outcome of a situation. This is when fears come, when this sinister phase of involvement, this involvement as limitedness is coming to voice. And this is also related to a very crucial thing in our thinking about crisis, to time perspective. Elias believes that involved thinking is always a short-term one. And it is doubly hindered that way in dealing with social processes. It does not only focus on the small we, it's also a short-term thinking. And if involvement is rising with fear, it leads to circles of violence which cause us to use our laws and other standards to defend our we perspective and group interest, and overshadows a bigger picture in which we are all living. Or, as Elias once put it, a bigger habitat in which we are all living. And this is also the problem of science, because science frequently tends to turn to the role of a servant of involvement, as he puts it, and deprives humanity of the aid against the problems whose scale is now unprecedented in history. And Elias believed that this context is unprecedented, and he was aware, I guess, of this context already in 1939 when he wrote that the question of socially generated fears emerges as one of the central problems of the civilizing process. And he was aware of the novel factors in our time when he noted that one can see the first outlines of a worldwide system of tensions. And this is a prelude of struggles, as he believed, embracing the whole globe, which are the precondition for a worldwide monopoly of physical force, central political institution, and pacification of the earth. This is a very naive vision, and of course it's the more naive that it was, well, actually the context to which he was referring was quite to the opposite of what he was thinking and hoping for. But the point about pacification of the earth is still valid, although the manner of pacification of the earth might have become quite different. And if we are not aware of this double phase of involvement, of this involvement as commitment and involvement as fearful attitude towards novelty, then I think we might not have a chance to pacify the earth in the global context, and in particular we might not be able to pacify the earth by means of understanding our legal differences and analyzing legal differences in an unbiased comparative scheme. And what I will be trying to do in this, in the time that remains me in this center, will be to develop all that I've said here into a viable reservoir of instruments to apply this involvement and detachment distinctions to legal analysis, and to try whether in comparative context it really might work without the ethnocentric bias as far as it can be avoided. So I really hope to hear a lot of comments and criticism from you, because my work can only be improved by having them. So please feel free to ask me, and I will be happy to elaborate on anything that I've said here. Thank you for your attention.